Good evening. So on the various platforms, I invited students who will be having some challenges with their uh, studies of preparation to share the specific questions or the challenges that they are having so that I will assist them. Some of you have reached out and uh, the ones I've been able to see them, I'm going to discuss them together. I'm not going to mention the names of those who ask the question. So in case you got a question and I am discussing it, don't be worried because your name will not be mentioned. But I think that probably what you encounter at your end may not be something unique to you, and other students may also be having a similar problem. So if we discuss it together, I think that those who have similar problems will have benefited, but those who don't have to have arrange of their yeah. So as I have told you before, please, when I come online, you have to mute yourself. Otherwise, I take you out. Okay, mute yourself. If you want to speak, you raise up your hand and then I'll allow you. Okay, thank you. Okay, so these are some of the questions as we are pushing towards the D-Day for some of you, especially those who are writing this for the first time or they have written it a couple of times. It's our hope that this year will be the last encounter so that you don't have to write it again. Good. So this is the, I just quoted the questions from the students' the WhatsApp chat. So just as the student brought the question, then I'll quote it and I'll endeavor to provide some kind of like a response. When I am done with the ones that I have, if there is time and I'm not tired and you're also not feeling sleepy, I may take a couple from you, those of you who are online. Okay, so I think the first question, student question one, please, is Office of Special Prosecutor part of Constitutional Law syllabus? Well, it may probably sound very basic or elementary to some of you. Nevertheless, once the person has a question, we cannot brush it aside. So this is the response that I am giving the one who has that question. Yes, depending upon how you are looking at it, special prosecutor is part of constitutional law. And as I said, depending upon how you're looking at it. Now, to start with, if you look at the Constitution of Ghana, it espouses or it seeks to advance principles of probity, accountability, and integrity. And if you look at the preamble of the Constitution, which at least just spend 2 minutes on your own, you just look at it, it's just about a half page, right? If you look at the preamble of the Ghana's Constitution, I think that it gives us a sense of how we try to fit some of these things into the whole we are thinking through. So, I mean, we the people of Ghana, in exercise of our natural right and so on, in the spirit of friendship, and let me good, the order I'm interested in, and in solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability. So clearly, the Constitution tells us that through the preamble statement that accountability and probity is part of what the constitutional order that we are seeking to establish. So that is the first point to keep in mind. And then again, if we look at the directive principles of state policy, We also see Article 35, Clause 8, that the state shall take steps to eradicate corrupt practices and abuse of power. Okay, so in the preamble to the Constitution, the framers of the Constitution have stated that we are trying to establish a society in which values of probity, accountability, probity, justice, accountability, and freedom will reign. And then we come to the directive principle of state policy, which we know is a clear statement of the vision that we are trying to move towards. And we see in the Lotto case, in a plethora of decision by the Supreme Court, that is supposed to guide everyone. So if you look at Article 33, Article 35 plus 8, we have like a direct statement that the state shall take steps to eradicate corrupt practices and abuse of power. And again, finally, if you look at the Article 41 itself, right, which is about the duties of the citizen. If you look at Article 41 Clause F, Article 41 Clause F will make the point that the exercise and enjoyment of rights and freedom is inseparable from the performance of duties and obligations. Accordingly, it shall be the duty of every citizen to protect and preserve public property, and oppose and combat the use of public funds and property. Good. So if you read all these constitutional provisions together, it gives you a clear impression that our constitution is actually seeking to eliminate corruption and so on from society. And so it perfectly dovetails into the mandate of the Office of Special Prosecutor. So that if you look at the Office of Special Prosecutor Act of 2017 at 959, you notice that the Special Prosecutor is empowered, among other things, to initiate investigation into corruption-related activities of politicians and public office holders, and also to prosecute. So therefore, my response to the questioner is that the Office of Special Prosecution is relevant to constitutional law because the Constitution seeks to prevent corruption. Then we come to another question by that same student who has the first question. Do you think please? Alice is going to be taken out of this class.
I don't know.
Okay. So you see, I've taken someone out of the class. So if you don't be taken out of the class, check your mic. Okay. As soon as I hear unprofessional noise from your end, I will not give any notice to you. I'll just take you out. Okay. You can later play the recording back if I'm able to upload it. Otherwise, that's it. Okay. So the other question by the other student is that, do you think there's a conflict between Attorney General and Office of the Special Prosecutor? Well, my response is that no, there is no conflict between the Office of Special Prosecutor and then the Attorney General. Particularly so, if you look at the legislation which establishes the Special Prosecutor, you notice that the Attorney General plays a role in the appointment of the Special Prosecutor. And again, if you look at the legislation, it also makes the point, especially if you look at the long title, the purpose statement of the legislation, that the Office of a Special Prosecutor or the Special Prosecutor may, on authority of the Attorney General, initiate and prosecute, corruption and corruption-related offenses and so on. So, to that extent, we do not have a conflict. However, I think what the student who asked that question probably ought to be asking is that, is the Office of Special Prosecutor really, really effective is it the statutory place in a very strong position to be able to deliver on this mandate, especially so when you look at the position of the Attorney General Minister of Justice. If we look at Article 88 of the Constitution of Ghana, we are told that the Attorney General is the principal legal advisor of the state, and then we're also told that all criminal prosecution shall be initiated by the Attorney General in the name of the Republic. And we know that the Attorney General is the one which has the power to initiate criminal prosecution or authorize people to initiate and conduct criminal prosecutions. We know the other associated powers, for example, the powers of null prosequa or withdrawer and so on. Null prosequa, at every point in time, the state, through Attorney General, can say that the state is no longer interested in prosecuting this particular offense or this particular person. For that matter, everything should come to an immediate end. Now, if you look at it from that perspective, then you may want to question whether the special prosecutor is put on a proper statutory pedestal to be able to fight corruption. Because if you get an Attorney General who does not cooperate with the special prosecutor, you can actually have some sort of like a crisis, because we know that in the hierarchy of legal norms, the constitutional provisions reign supreme. So therefore, if the Constitution per Article 8 says that it is Attorney General who has the power to actually conduct criminal prosecution in the name of the Republic and all that, then if the special prosecutor is, for example, doing a particular prosecution, the Attorney General, if assuming there's no cooperation between the Attorney General and then the Office of Special Prosecutor, you could have this constitutional power being asserted, and may end up going to the Supreme Court and all that. And the provision is quite clear, and there's no way that you get the interpretation which says that the Office of Special Prosecutor can actually supersede. Somebody is called Raf. Yeah, so please check your mic, otherwise all of you will be removed and I'll be left alone here talking. Yeah, so that is that's the challenge. Particularly so, if you look at the fact that, let's say you have like a change in government, right? And the holder of the Office of Special Prosecutor position was not appointed by, let's say that the particular government in office now. And let's suppose there's that kind of lack of cooperation between the holder of the Office of Special Prosecution, Prosecutors Office, and then the Attorney General. Then you are going to have rare challenges. So I think that the person who has a question, those are the kind of things you should be thinking about. Then student question number 2, that is another student also has a question. And as I told you, I just copy and paste the question as you send to my WhatsApp chat. I'll put it on a platform that if you can send me a DM or something. Some of you did that. So this is what another person said, and I quote: "The trending effect of coup d'etat in West Africa region, and how does it affect the rule of legal and democratic regime?" So that is how the student put the question.
definitely dey inside and na for small money posting channels na so your customers go dey see your business so who informate rush go.
Yeah. Yeah, so to that question, that's the second student. The question is essentially, if you look at how he or she put it, trying to explore the legal effect of coup d'etats or revolution on pre-existing legal or constitutional order, okay? And my response is that the legal effect of coup d'etat or revolution on pre-existing constitutional order is contested among scholars. That is to say that we do not have one universally accepted position that when you have like a successful coup d'etat, it is this or it is that. So as you know, among constitutional law scholars or students, we have two main schools of thought, the theory of continuity and then the theory of discontinuity. The theory of continuity simply holds the view that when there's a coup d'etat or revolution, it does not actually erase, it does not sweep away the pre-existing constitutional order. That is to say that the constitutional order or arrangements which were in place before the coup event will not automatically be swept away. And as a matter of fact, it will remain in force. There may be some adjustments here and there. For example, as regarding who holds executive power and probably who exercises legislative power, there may be some changes, but that is not to say that there has been like a complete eradication of the pre-existing legal order, as it were. Of course, as I said, this is like a theory, and they will also have like its counter version, and this counter version is discontinuity. And the theory of discontinuity, students know very well from your first year studies of constitutional law, associated with the jurist called Hans Kelsen in his famous work, The General Theory of State, his pure theory of law, where he advances the view that the legal order is like an inverted, collapsible pyramid. Pyramid is like this. Pyramid, a bit like a triangle with the apex pointing upwards. But then Kelsen would say that for purposes of the theory of discontinuity, the pyramid is inverted so that like the apex is down, right? And then the base is rather facing upwards. And the apex is like the GRU norm, the most primary norm, which gives efficacy or legitimacy or validity to all succeeding norms. And according to him, and those who believe in the history of discontinuity, that once a coup d'etat has been successful or revolution has been successful, what it means is that all the pre-existing legal arrangements will be swept away, in the sense that from the moment that the coup d'etat or the revolution became very successful, legal validity with respect to any law, with respect to any institution or anything thereafter, will have to be traced to the authority of, if you like, those who made the revolution, or like the coup d'etat, and they will become the, if you like, the validating norm. So you call like the GRU norm. Of course, if you are to go strictly by his own teaching on the GRU norm, it will be very difficult for you to sustain the logic of it. But I'm not going to worry you ahead with that now, just to let you know that these theories are there. And then there are a couple of case law, which you can spend time reading them if you have forgotten them. The case of Salaves Attorney General, Espati Matovo, case of Ladnabek and Mazimabutu, and then the DPP and Michelle. If you go online, you can download all these cases and read them. And also the Nigerian case of what you call the Lakami case. Some references are made to these theories regarding the effect of coup d'etat or revolutions on the pre-existing constitutional order. Now we come to this aspect. What about the situation in Ghana? If you look at our constitution, that is the 1992 constitution, the point needs to be made that it does not recognize any coup d'etat or revolution, and it rather encourages resistance to any coup d'etat. And all of us, as students of Ghana constitutional law, are very familiar with Article 3 of the Constitution. I've just quoted Article 3. So apart from Article 3, clause 1 saying that Parliament does not have the power to enact a law establishing Ghana as one-party state, it also emphasizes that anybody who will engage in any activity which seeks to suppress political activity of any other person or class of person is unlawful. And then Article 3, clause 3, which is more pregnant in terms of what we are currently discussing, makes the point that any person who by himself or in concert with others, by any violent or other unlawful means, suspends, overthrows, or abrogates this constitution or any part of it, or attempts to do any such act, or aids and abets in any manner any person referred to in paragraph A of this clause commits offense of high treason and shall upon conviction be sentenced to suffer death. And Article 4 says that all citizens shall have the right and duty at all times to defend this constitution and to resist any group of persons who are seeking to overthrow the constitution. And so therefore, we say that as far as Ghana is concerned, there's nothing like successful coup d'etat. The framers of the constitution require that if there is any coup d'etat or revolution, any Ghanaian or all Ghanaians should continue to resist the junta, should continue to resist the coup makers until they succeed in chasing the coup makers out and restoring the constitutional order. And even if in the process you kill people, you are not going to be charged with murder. If in the process you suffer any harm, you are going to be compensated from the consolidated fund of Ghana, as it were. So Article 3 actually tells you how resolved our framers of the Constitution are with respect to protecting the constitutional order and resisting any attempt to overthrow the Constitution. So therefore, we say that for Ghana, the theory of discontinuity does not have any effect. And the theory of continuity has no relevance because our Constitution has charged every citizen to continue to engage in acts of resistance unto any coup maker or anybody who attempted to overthrow the constitutional order until he or she has succeeded in chasing them out of office, as it were. So let's keep that in mind. Now, another student, that's the student number 3, asked the question. Please, I would like to, I said, I quoted it from the WhatsApps. So sometimes we have some significant inelegance or some infelicity, so don't worry about that. Okay, and Anaba Frederick, what is the question? Your hand is up.
Okay.
Hello, Doc.
Yes.
I wanted to know with the discontinuity theory. do you need to add people like heart and others so far as the positivity is concerned, or you can use only Kelson's theory and conclude?
All right. So Hart discusses the primary and then the secondary rules. And so Hart will talk about the rules of succession, the rules of recognition, and then what is the third one? The rules of change. And
yes.
Yeah, good. So if we are looking at the Hartian concept of law, Hart will make the point that if you take law is not that very simple. Law is made up of different set of rules or norms. Some of them just define what we are supposed to do or what we are not supposed to do, the primary rules. And then some also provide guidance regarding how we should determine whether the primary rule has been complied with or has not been complied with. So we talk about the rules of what? Adjudication. So there will be a dispute. Someone will say that you violated my interest or my right. We need to determine whether that is true or not. And we need another law to help you to go through that process. So that will be like the rules of what? Adjudication. It's a part of the secondary rules. And again, we also need to know, the primary rules, they can go through changes as society is dynamic. So how can we know that we've added some of the rules to the system, or we've taken some out? So you need some rules of what? Recognition, as it were, and rules of change to help us to determine how we've added to the primary rules and then how we've taken out and all that. And again, when it comes to even like the making of, let's say, the primary rules, we have like parliament, okay? How we determine who qualifies to be a lawmaker and all that. All these are also determined by another set of rules. So therefore, if you bring that to bear on coup d'etat, and Hart is a positivist, right? And the positivists, they take the view that the law is that which is positive. So if you are going by that, if there's a coup d'etat, then one will argue that the new person who is able to superimpose himself as like the new lawmaker, it is that which he will postulate, which will be like the law. And you can cite example from the proclamations which are made by coup makers. If you look at Ghana's past, for example, the FRC proclamation, they'll say that the constitution is suspended, this and this and this and that. And then from that time going, any thing which remain will have to be because the new lawmaker has put forward that is the law. Yeah, so that is another way which some theorists will try to reason out the situation of effect of coup d'etat from the positivist point of view. That is the Hart's concept of law. And also another positivist like the Hans Kelsen, and he comes from like, if you like, a bit of a varied approach. But as I said, these theories are there, but as far as our country is concerned, in terms of Article 3 of the Constitution, they do not have any relevance.
Thank you. Thank you, Doc.
All right, so another question, please. I would like to find out if you can claim compensation under the Civil Liability Act for loss of limb or essential body part like arm or eye, which leaves you incapacitated. the injury was as a result of someone's negligent act, please. So this is the question I've quoted from the student who asked it. I don't know, he or she. Good. Now, we have to remember that the Civil Liability Act of 1963 at 176 deals with what we call contributory negligence. Contributory negligence, as you remember, where you have established a claim of negligence against someone, that the person owed you a duty of care, he has breached a duty of care. As a result of his breach of duty of care, you have suffered injury and so on. Then that person will also put up the defense that, and notwithstanding all that you have said, yes, the injury that you've suffered, you are to be blamed. You also contributed to that. Now, the law on contributory negligence, was not quite clear at common law. For that matter, when our lawmakers passed the Civil Liability Act, they provided more clarity regarding how the concept of contributory negligence should apply in Ghana. And then again, it also deals with what we call the survival of causes of action, right? There used to be a point in time in common law that when a person died, his cause of action also died with him and so on. But that has changed statutorily. And Ghana, for example, per our Civil Liability Act says that if someone had the right to sue for a particular claim or interest, the fact that he has died will not automatically bring an end to that claim. And it works in the reverse. If you had a claim against someone, the fact that the person has died will not bring an end to that claim. In either case, the estate of the person, if we say like the estate of the person, that is those who are going to stand as a personal representative to take charge of the affairs of the deceased person, that is the estate, will be able to maintain an action for whatever claim that if the person were to be alive, he will have been entitled to pursue. And in a similar vein, if any third party had any claim against this deceased person, he or she will be able to bring it against his estate through his personal representative. Then the other 10 Civil Liability Act seeks to do is also to deal with award of damages in fatal accidents, including where people die in maybe air crash and so on, as well as in other forms of like the normal accidents caused by negligence and all that. Now, where that happens, the person certainly might have had dependents, people who depended upon him or her, but because this person is deceased, they are going to suffer. And that is why the law came in to provide some rubrics to guide us to determine how those who were depending upon this deceased person are going to be given some compensation according to what they will have been entitled to be taken from this deceased person. Of course, in relation to whatever compensation that the court will consider just to take against those who cause the death of this particular deceased person. Now, we come back to the student's question. Now, if you were a victim of a tort of negligence, you have suffered injury to your limb or to eye or whatever, if you are not, if the issue of contributory negligence has not come up, you don't necessarily need the Civil Liability Act to be able to prosecute your claim. The Civil Liability Act, as I said, is supposed to address certain special cases as we have gone through. So the general law of negligence is still there. And as you know, the causation, remoteness of damages, and all that, they are applicable. So whatever injury which you think the rules on or the principles on causation and remoteness of damages allow you to actually recover compensation from, you will be able to do that. And you don't necessarily need to be able to premise it on Civil Liability Act, especially so if you, the plaintiff, you are alive, right? Because if you look at the Civil Liability Act, as I said, apart from the contributory negligence, the bulk of the thing addresses the situation where the victim of, let's say, the negligence or the accident is, for example, disease, and then his estate, and so on. Then we come to student question number 5. Another student had the question, and here's the question. Respectfully, can you help me with some cases that treated illegality in contract into detail? Okay, so my response to that student is that I think I have done 2 lectures earlier on the YouTube on illegality. If you can locate it and play it back, it will help you. If you can get Mrs. Donna Hammond's book and look at the chapter on legality, to help you. And again, look at the case of City and Country Waste Limited against Accra Metropolitan Assembly. I have made the point that for effects of illegality, if you not read any case in Ghana, you have to read this particular case, because this case actually made an important contribution to the law on illegality. In what respect? As you notice, there was supposed to be a contract between the Accra Metropolitan Assembly and then the City and Country Waste Limited, but the contract was concluded in a way which offended the requirements of the law which governs the Metropolitan Assembly and all that. So an issue arose as whether that contract could be enforced, because it didn't satisfy the requirements of the standing orders of the Accra Metropolitan Assembly. And the court made the point that insofar as it did not satisfy the standing orders, and including going through the tendering process and all that, that was illegal, right? That was illegal. And one would say that that's an illegal contract. But here is the case. The City and Country Waste Limited had already performed services, right, for the Accra Metropolitan Assembly. Now, at common law, the position would simply have been that once the contract had been declared illegal, unless you could demonstrate that you and the other party are not what they call in pari delito, you are not equally guilty of the illegality, then you will be able to enforce it if we can also sever the illegal bit from the rest of the other contract, the severance principle, or if there had been change of mind, locus ponentia, before the contract was implemented. So these were some of the very limited exceptions at common law where a person could recover a property or money transferred under illegal contract. But in Ghana, so please mute yourself, otherwise. Okay. So in Ghana, Justice Dr. Dateba, speaking for the Supreme Court, took the view that we don't have to follow the traditional common law or the conventional common law position. We need to look at the realities of our situation and also come out with a position which is fair and just. So in this particular case, the court said that yes, what the AMA did was illegal. But here is the case. The AMA has actually benefited from all these services. So it will amount to what we call unjust enrichment. If the court were to say that simply because AMA did not follow its standing orders, it did not go through the tendering or the procurement processes, everything is illegal. Yes, all the services have been rendered, but it's illegal, so we cannot get any payment. That is unjust enrichment. So the Supreme Court actually brought in the equitable principle of restitution and said that, yes, we are going to have a flexible approach and will not tie ourselves down to the limited exception at common law regarding recovery of monies or properties transferred under legal contract, and give results which we consider to be just. So in the circumstances of the city and country waste against EMA, the court felt that using the restitutionary principle in order to guard against unjust enrichment in the sense that EMA, you are benefited from the services by city and country waste, and yet because you didn't comply with your own legal processes, you are saying that you shouldn't be made to pay for the services. I mean, that is unjust. And that is what the court sought to correct. So the takeaway from the city and country waste against EMA is that the Supreme Court sought to have a flexible approach, right, towards recovery of monies or property transfer under illegal contracts. So let's keep that in mind. But the point needs to be made that when we are talking about illegal contracts, in Ghana, we also have a constitution, okay? And if you look at the hierarchy of legal norms or rules in Ghana, the constitution is number one. But if you look at the contract, the topic illegality, you notice that the common law illegalities actually revolves around public policy and statutes, right? But here is the case, our constitution, per Article 2, supremacy of the constitution and all that. So where a contract, for example, is concluded or it violates the provision of the constitution, that is unconstitutional, okay? And if it's unconstitutional, can we allow restitutional principle, as we saw in the case of city and country waste against EMA, to apply? Well, for this particular point, there are two articles, one by my humble self and then one by a colleague, Jonathan Asare, which I will encourage you to look at. So illegality of contracts in Ghana, filling the gap, and then unenforceability of contract, our fundamental human rights and freedoms, and Ghana's 1992 constitutional grants of public policy. But the brief, if you don't have the time to read them, what you have to remember now is that in a number of cases, which really pertain to, one would say, a contract involving like the state and so on. The case of Attorney General against the Faro Atlantic, Amidu number 2 against the Attorney General, Esophoton against the Forsen number 1. The Supreme Court, having concluded that the relevant transactions or contract were unconstitutional, did not go by the decision or the approach which they had only propounded in city and country waste against EMA, and rather ordered refund of the payment made by the state. So therefore, in the case of, let's say, in Debrugi against the Attorney General and so on, the court, speaking through Justice Benin, will make the point that, quote, the plaintiff has raised this issue in view of the court decision in these cases. Amidu number 3 against Attorney General, Waterville Holdings and Oyomi number 2. Amidu number 2 against Attorney General and others. Called Amidu cases for short. These cases decided entirely that when the contract is invalid because it violated the constitution, then all acts done under it, including payment of money, could not hold, and that no order of restitution could be made under such invalid contract. It was for that reason that payments made under those contracts were ordered refunded to the state, unquote. So our learning from these cases is that where the court comes to the conclusion that certain contracts or transactions were unconstitutional, then the court will not allow any of the exceptions at common law or even the new approach which the court had come up in the case of City and Country Waste against the AMA to apply. But mind you, in the City and Country Waste Limited against AMA, it was not about constitutionality. It was about violation of a statute or standing orders. But in this case, it was about the constitution. And the Supreme Court is saying that where the contract or the transaction is unconstitutional, then that is it. Will not allow any recovery or any restitution under it. So let us keep that in mind. I think another thing, yeah, I think somebody also brought this question. Good evening, my Lord. Please address this question for us in terms of area of law. We have some disagreements. So this is the question the person put there, and you call it a sample question. Kofi entered into an agreement or contract with AMA for the sale of land. Kofi paid the full purchase price of 1 million Ghana cedis. At the time they agreed on the sale, AMA had used the land, a collateral for a loan. It was agreed between Kofi and AMA that after Kofi pays the purchase price, some of the money will be used to redeem the property. And where the property is redeemed, then AMA will execute a deed of purchase for Kofi. AMA redeemed the property. After the redemption, Kwesi approached AMA for the land, and Kwesi offered 2 million Ghana cedis for the purchase of the land. AMA agreed with Kwesi and has executed a deed of purchase for Kwesi for the sale of the land. Kofi has heard about the transaction between AMA and Kwesi, and he's aggrieved. Kofi has come to you for advice. Advise Kofi. So according to the question, I think they had disagreement over the particular area of the law which the question belongs. Well, as I keep telling you, always remember your IRAC or IPAC, the area of law, the issues, and then the relevant principles, application, analysis, and conclusion. Now, my advice in this type of question would be that there are two sets of transactions. We'll deal with the first one first. The transaction between Kofi and AMA. There's an agreement to enter into contract for purchase of land, expectant on redemption of mortgage. So that is the first agreement. Kofi and AMA, they've made an agreement. Kofi is very much aware that AMA has a land, and that land is currently encumbered by a mortgage, as it were, or some collateral arrangement. But Kofi is interested in AMA transferring her interest in that subject property once it has been freed from the encumbrance, when it has been redeemed to Kofi. So they make that agreement with the understanding that there will be a proper contract of transfer to Kofi. So Kofi has paid the agreed consideration, 1 million Ghana cedis. And it was part of the agreement also that when Kofi has paid the purchase price, part of it will be used to pay off, that is to settle the underlying debt, for which reason the land is a security. So to redeem the property which has been used as a collateral. So Kofi has paid, the property is redeemed, and AMA, instead of proceeding to execute the deed, to execute like the deed of purchase, right? The formal contract, transferring interest to Kofi. Rather get someone who is prepared to pay 2 times what Kofi has paid and decide to right away execute the deed of purchase for the person who is paying 2 times what Kofi had paid her. So that is the situation. So as I said, you do the first one first. So the first one is simply about the agreement to enter the contract of purchase of land expected on redemption of mortgage. And you should be thinking about remedy like specific performance directed at AMA to execute the deed. Because the agreement between Kofi and AMA is in relation to a land. And as you know, when it comes to land, no 2 lands are the same. And for that matter, in equity, the courts are more inclined to decrease specific performance, as it were. So you should be exploring that. Then again, you come to the other scenario. Deal and that are between Kwasi and Ama, right? The second as the transaction. So we need to find out, is Kwasi bona fide purchaser for value without notice? In other words, when Kwasi was actually going to buy the land from Ama, can we say that he was completely innocent? He didn't know that Kofi had a claim and so on. Well, if we look at the facts, we don't have enough information to actually determine whether Kwasi conducted and so on from the Lands Commission and collateral registry to know the true state of affairs and so on. So we cannot actually deal with that, but you can raise it and just dismiss it right away. Then you come to, is the transaction between Kwasi and Ama, is it tainted with fraud? In the sense that Ama, at the time of entering the transaction with the Kwasi, knew very well that she couldn't do that because she had a contractual obligation to enter into formal contract to transfer the interest in the land to Kofi. Kofi having already paid the agreed consideration. And so these are the kind of things that you need to be addressing your mind to. Okay, then there's another question by another student. Please, can you assist us with the issue of legibility of authorities in exams? Because at faculty level, when I underline authorities in exam, it doesn't appear underlined, and that's not legible. So this student's question. Okay, my response is that examiners mark under extreme pressure, okay? So writing your authorities to stand out or underline them will be greatly welcome. Examiners are marking a lot of scripts and they shouldn't struggle to actually see the point that you are trying to make. So please, I will encourage you that in terms of authorities, if you can let them really stand out, either boldly or you underline them, that would be great. Okay, that would be great. The advantage of letting your authority stand out is that if, for example, your writing is horrible and your examiner is getting mental fatigue, struggling to make sense of what you've written, if the authorities are standing out, the authority will serve as gravitational pull for your examiner to face his eye and read everything you have done. But if he has a marking scheme, if the relevant authorities and all that he's read a few paragraphs of your answer, you're not making sense, is struggling to actually even see your writing, the person is marking under extreme pressure, a lot of scripts. You just form some global picture and award you mark and move on. But if the authorities are standing out, the authorities will stand as gravitational pull. Let the examiner know that no, These students, is worthy of more attention because he or she is on the right path. Examiners don't waste time on students who are deviated, okay? If the examiner gets the earliest indication that you've deviated, he will run his eye through your answer quickly, and you will still feel that you are deviated. He will just give you a score for deviation. So pay attention to that. So if you can write well and let your authority stand out, I think that will be a good thing which should be encouraged and it will serve you well. I think there's another question by another student. Please, I would like to ask where we have a problem question and raise our issue. Should we conclude on the individual issues or we should have one general conclusion? That's somebody's question. Well, as I've done extensive tutorial on how to answer questions. I'm sure all of you have played that video. You sat through it. I did two. One on how to solve a problem-based question, that is using the IRAC or the IPAC, and then another on how to solve an essay question. So with respect to the problem-based question, I advise that every issue, because the issue is a legal word, it's a legal question. So when you have discussed it, definitely, you cannot discuss an issue without concluding on it. Because the conclusion on that issue is your answer to that issue. You have, let's say, about 3 or 4 issues, right? Emanating from a passage or the problem that will be given. You state the relevant principles and then the corresponding authorities, and then you do the analysis and application to find out whether the facts that you have actually satisfy the stated principles and whether the corresponding authorities, any of them have got like facts which are on all fours or which are just similar as the facts before you. For that matter, they sort of support the analysis that you are doing and the conclusion that you are reaching. So when you finish that particular issue, actually, your answer to that issue is a conclusion on that issue. And then you move on to another issue. Now, when you have done discussing all the issues that you raise, you need to draw the big conclusion. And the big conclusion, problem-based question, usually you are asked to advise the parties or you're asked to do something. So the big conclusion will be an effort to pull all the small conclusions together. And then if you are asked to advise, then you give your advice. If you are asked to do any particular thing, then you do that. Yeah, so you need to follow that approach. That way you don't leave anything out. I think these are the questions that I have come across. Yeah, if there is anything bothering you, maybe 5 minutes, I will take it before we close. It's 11. Okay, right. You go to work tomorrow. Yes. And if there's no question, after a good, okay, let me see, there's something in the chat.
Hello, good evening, my lord.
Yes, good evening.
Please, going back to the land question, the issue on the question on land.
Yes.
Which you said that, I think Kwame also, Kwesi didn't, the question was not clear whether Kwesi conducted the search.
Okay.
Please, just a quick run through of the steps to take when you want to conduct the search. I know that you have to go to the Lands Commission, you have to go to District Assembly, and maybe the land itself. Visit the land.
Okay, good.
So
Yeah,
what are the
so the search As you rightly said, you go to like the lands commission. Of course, you commission the search there. You send a request regarding the particular land. It will be named in the request. And then you want to find out all transactions affecting that particular land. And they will list them. So if you get the results, and let's say that the results does not say anything about like anything linking transaction between Amma and Kofi, right, to the records held there, then Kwesi is innocent because he doesn't know that there's anything between Amma and Kofi. Because he's going to conduct the search, and the search revealed to him that there's no encumbrance or there's no outstanding claim or interest, which will prevent him from acquiring the interest and so on. So those are some of the things. Yes, Dr. Prempe.
Thank you so much, sir. We are really grateful, doctor. Please, just the answer you just gave brought my mind to the pending Cecilia Dapa case. We are all aware that the people who purchased the property and car from the housemates and their boyfriends, those people were also picked up by, I think, what you call it, prosecutor,
Right.
the special prosecutor, and were given bail later on. So if someone purchases a stolen item or stolen property, doesn't mean that in the case where Kwesi purchased the land, which technically belonged to Kofi because he had settled on that with Amma, and Kwesi was oblivious to the fact that Amma and Kofi had a deal, and he went ahead and purchased it. So if you purchase an item that doesn't belong to the seller, aren't you also a culprit, or in any case, won't you be
right.
picked up?
Yeah, I get your point. If you look at the New Land Act, the New Land of 2020, the Act 1036 also, yeah. If you look at that legislation, you know that there's an offense where you do multiple sale of land. So if there's a criminal offense at all, it is Amma who has committed the offense.
Right.
Because
right.
Amma has actually sold the land to Kofi. And so Amma will definitely be caught by provisions of the Land Act, which makes it an offense to sell, land to more than one person, the same land to more than one person at the same, different times and all that. Yes. But in terms of like the Kwesi, what we call dishonestly receiving and all that.
Yes,
exactly.
exactly.
Not apply, because dishonestly receiving usually applies to what we call the movables, right? Not a landed property, like movables, like chattels and so on.
I believe those were the conditions that also provoked the Otunfo to distill some of the chiefs because they sold a piece of land to multiple people.
Yes.
So
yes.
those chiefs that were distilled, can they also be prosecuted under criminal law?
Oh, why not? They can. If there is evidence that the chief sold land to X, and the same land he sold it on different occasions to Y, knowing that he has already sold it to X, then that is a criminal offense. Yes. Okay, so there seems no questions. So have a very good night.